Good morning all. Once again, I have the pleasure of welcoming quite a number of members of the profession to agreeing to this presentation. This morning we have three topics to cover. We're going to be struggling to get them done in the time that is allocated. First of all, the first speaker will be Catherine Boston, who's beside me. Before coming to the bar, Catherine was an associate to Justice Whelan. In 2010, she completed the BCL at Oxford, having received the Alan Myers scholarship to do that, to obtain a master's. She has a general practice in criminal law. She's had a particular focus in her time at the bar on appeals in Victoria and the High Court. She has spent a considerable amount of time with I think Michael Croucher in particular before he was appointed. She has also, to my great benefit, been a junior in a recent matter in the Supreme Court. She was part of the barrister team in the celebrated case of Monash. Next to her we have Justin Hannebery. Justin is no doubt well known to most of you. He's been around for a shy fellow who's been around for quite some time now. He has an extensive criminal practice both in the Supreme Court and in county court trials, in criminal and OHS matters. He's been a long-serving member of the Bar Council and also a long-serving member of the Committee of the Criminal Bar Association. Next to him we have Andrew Sim, who's only recently come to the bar, having been a senior lawyer at VLA and at the Commonwealth OPP. He's worked on both sides of the fence in respect of general criminal matters and in particular has significant experience in serious Commonwealth crime, indictable offences, everything from people trafficking to international extraditions. The way in which these things come together is a group of us tend to get together. We get offered a free lunch by Greens. We work out what we might speak about, and of course we all tend to draw on our own recent experiences and we look for things which are quite topical. So in this case, Catherine's topic will traverse rulings that perhaps surprisingly favourable to the defence that were made in a recent trial in which we were involved, an attempted importation of a large commercial quantity, so much of what she'll be talking about arises from rulings made by Justice Kay in that case. Andrew has special insights arising from his personal involvement in the High Court challenge to the retrospective or potentially retrospective social security laws in Keating. And Justin has drawn together a valuable analysis in respect of some of the Commonwealth internet offences, which of course are occupying us more and more as the years go by. Unfortunately, I'm in the middle of a trial and something's come up which is going to mean that I have to go off very quickly, but I'll leave it to Justin to tie things up at the end of the day. If I might make one very minor contribution before I do go, there has been, many of us I think over the years have experienced that situation in which police haul somebody in for an interview in the early hours of the morning, throw the phone book at them, say, do you want to get a solicitor? They make a few phone calls and no solicitors there, push ahead with a record of interview. In a case which was in a ruling in December last year, Justice Nettle in a case of GOPAL, G-O-P-A-L, ruling number 1, threw out a record interview which had occurred in those circumstances. I mention that to you because it's something that we often come across, and it's that interview, that ruling hasn't yet been published because of the fact that there are ongoing separate trials. So if you find yourselves in a situation where that ruling might be of benefit to you, get in touch with me or Chris Winnicky, who's my junior in that case, and a copy of that will be made available to you. But look, we have a bit to get through, so I'd ask Catherine Boston to kick off in explaining to us some of the more esoteric facets of the Commonwealth Criminal Code. That assumes that there is some facet of the Commonwealth Criminal Code which is not esoteric, which is very doubtful. But thanks, Catherine.
So I will be talking about extensions of criminal responsibility under the Code, as Michael said. But since I'm the first speaker, I thought it might be useful to make a few general introductory remarks about the Code. As we know, the Crimes Act 1914 and the Commonwealth Criminal Code are the two major pieces of legislation, criminal legislation in the Commonwealth jurisdiction. And sometimes, from a personal point of view, I find the line between those two acts can be a little bit blurry because we do have some offences in both of those acts. Many of you will be well aware of the contents of the two acts, but just in case you are not aware of what's in them, essentially the Crimes Act 1914 contains provisions about the investigation of and sentencing for Commonwealth criminal offences, and it also does contain some procedural law, although by virtue of the Judiciary Act, obviously the Criminal Procedure Act and Victoria's Evidence Act do also apply to Commonwealth prosecutions. As I said, the Crimes Act does still contain some offences relating, and they relate mainly to the administration of justice, but the Crimes Act did used to contain a lot more offences. Most of those have been repealed though, and similar offences are now contained within the Criminal Code Act. So the Criminal Code Act also contains what it calls principles of criminal responsibility, which are applicable to all Commonwealth offences, and also does contain a significant number of offences in it, some of which Justin and Andrew will be speaking to you about. I think in order to fully grasp some of the, in my view, complicated issues which the Code contains, or gives rise to rather, it is necessary to have a little bit of an understanding of the history of the Code, and I apologise if you're well aware of the history and I'm just repeating what you already know. But in 1987, the federal government established the Gibbs Committee to consider the state of the Commonwealth criminal law. And at that time, the principles of criminal responsibility which were applicable to any given trial varied depending on whether the offence, the relevant offence was contained in the Commonwealth Crimes Act or some other Commonwealth legislation. And that was obviously a very unsatisfactory and confusing state of affairs. So in 1990, the Gibbs Committee recommended that any proposed consolidation of the Commonwealth criminal law include a comprehensive restatement of the principles of criminal responsibility. And at about that time, the Model Criminal Code Officers Committee was established to review the criminal law in each Australian jurisdiction, and their report was released in 1992, and that report effectively was adopted through the enactment of the Criminal Code Act. It is Criminal Code Act 1995. Essentially, it only applies, however, to offences which were committed from the 15th of December 2001. So as I said, the aim of the code was to simplify and clarify the criminal principles which applied to Commonwealth prosecutions. Unfortunately, in my view, the opposite result has been achieved. The criminal code, in my view, is a bit of a minefield. It's full of sometimes, often complex and sometimes what appear to be contradictory provisions. As usual, Justice Hayden said it best in CDPP and Poniatowska, citations in the handout that you will have received. His Honour said this: "The proposition advanced by the responsible minister when the code was introduced into the House of Representatives in 1995 was that it would reflect Benthamite ideals of certainty in the criminal law. One does not often encounter a more striking illustration of the vanity of human wishes. This is because very many parts of the code, including the parts debated in this appeal, are inconsistent with those ideals. They represent a significant regression from the condition of Commonwealth, state and territory criminal law as it was before 1995. That criminal litigation under the code is conducted with any semblance of ordered justice is a tribute to the Australian legal profession." Quite strong words, one might think, from a High Court judge about a piece of legislation. So I will be talking about just a few of the difficulties with the way that the code works, or trying to decipher what is intended. And in particular, I'll be focusing on the provisions relating to extensions of criminal responsibility. So, where somebody's not liable as a principal offender in a direct sense. This is important because the High Court in 2011 in Hanlon, and again the citation is in that handout, held that there is no criminal responsibility except as contained in the code. So common law principles of criminal responsibility have not been imported, except there is an exception which I'll get to in a minute. So the relevant sections you should have received a handout about, and they're sections 11.1 to 11.6. 11.1 relates to attempt, and I think a lot of people assume again that it's just the common law of attempt, but it's not. The code codifies that law, and so really you need to be looking at what's contained in the section. Draw your attention in particular to subsection 3. For the offence of attempting to commit an offence, intention and knowledge are fault elements in relation to each physical element of the offence attempted. Now, fault elements effectively, the mens rea, and your physical elements effectively your actus reus, obviously. My reading of that section is that recklessness would not be enough, negligence would not be enough, it has to be intention or knowledge. But I've recently come across a case of O'Meara, again listed in your materials. It's a New South Wales decision from 2009 where the Court of Criminal Appeal there held that recklessness will suffice as a fault element for attempt. So, and the court there held that the appellant had been unable to cite any authority for the contrary proposition, and said that there was no reason from a reading of the section that would not be so. From a personal point of view, my reading of the section is that recklessness would not be sufficient, so I query the correctness of that decision, but it's one which we need to be aware of as practitioners. In addition to the trial that Michael mentioned, which I was fortunate to recently junior him in, I have also recently juniored in an appeal to Peter Morrissey in the Court of Appeal where issues regarding attempt under the Criminal Code were discussed, and that's the decision of Weng. It's a very recent decision, only about a month or so ago was judgment handed down. And one of the normal contexts or common contexts in which the Commonwealth will charge a person with attempt is in attempting to possess drugs, which have been, or a border controlled drug I should say, which has been unlawfully imported in various quantities. And in that case of Weng, in Obiter, the Court of Appeal rejected a contention by the appellant that knowledge of the particular drug was required. So the state of the law, at least in Obiter, is that the Crown need not prove knowledge of the particular drug where you've got a charge of attempting to possess a border-controlled drug. The appeal succeeded on a different ground, so strictly speaking it's Obiter, but I don't think you're going to see trial division judges querying the accuracy of the court's very considered Obiter in that case. I will just very quickly, because of the time, detail a few of the other issues with the other sections. 11.2 is entitled Complicity and Common Purpose. It's a very misleading title. Effectively, that section relates to aiding and abetting, not to the common law doctrine of common purpose, joint criminal enterprise. And in Hanlon, that case, that High Court case I mentioned before, that was confirmed. 11.2a was introduced because of that problem which was identified in Hanlon. So 11.2a, entitled Joint Commission, is effectively, it's very similar to your common law principle of common purpose acting in concert. But in France, the case that Michael was referring to, in a ruling in that case, ruling number 1, Justice Kay held that despite the fact that 11.2a refers to conduct of one or more parties in accordance with the agreement and not specifically to the conduct of the accused, the prosecution is still required to prove an act of participation by the accused. So this is obviously a decision of one Supreme Court Justice, and we're yet to see whether that's a decision which will be followed by other judges, but it is a decision which is very, very helpful to the defence, because on its face one might think that 11.2a doesn't require that the Crown prove an act of participation by the accused, which was obviously something which was required at common law. Just briefly, because of the time, I might just raise one issue, and that relates to conspiracy, which is under 11.5. And I draw your attention in particular to subsection 6, which states a court may dismiss a charge of conspiracy if it thinks that the interests of justice require it to do so. There's very, very little law on this section, and I'm not sure why there's not more practitioners trying to make use of this charge. The courts have often noted that there is that the charge of conspiracy is open to abuse, because obviously it's much easier for the Crown to prove a charge of conspiracy if they only have to prove the agreement and the overt act, and not the substantive offence which was actually committed. It's been called the prosecutor's darling for that reason. But in my view, there are two situations where we as practitioners should consider making an application for a charge of conspiracy to be dismissed. And that's firstly where the substantive charge is the more appropriate charge. And secondly, where the substantive charge is itself an inchoate offence. So, for example, the charges relating to terrorism, and in particular, section 101.6 of the Code, which is acts done in preparation for or planning terrorist acts. So obviously the substantive offence there is itself an inchoate offence. So it may be that in certain situations it wouldn't be appropriate to have a conspiracy to commit that offence, because you've effectively got a double layer of an inchoate offence, which is something which the common law would not contemplate, would not allow. Obviously, it's going to depend on the circumstances of the case as to whether that would be an appropriate application to be made, but it's something to keep in mind. And given the time, I might hand over to Justin.
Thanks, Catherine. Thanks, Catherine. Now, I'm speaking today about offences under the Commonwealth Code relating to internet communications between adults and children under 16. And basically, the code creates 3 separate offences that an adult can create, that can commit when they are communicating either via email or through chat room or something similar to that nature with someone they believe to be under 16. In descending order of seriousness, there's the offence of procuring that has a 15-year maximum penalty, grooming with a 12-year maximum penalty, and transmitting indecent communication with a 7-year maximum penalty. Now, these offences have in common that, firstly, they obviously all have to be committed by adults. You have to be over 18 years old to have committed those offences. And secondly, you have to have used a carriage service to transmit a communication. That's generally meant email, chat rooms, something similar to that nature. And thirdly, the recipient has to have either been under 16 years of age or the sender believe them to be under 16 years of age. Now, that's been an important component of these offences, because quite clearly many of the times these offences are prosecuted, it's not a real person who the sender is relaying material to. It's a fictional person, most likely the creation of an adult police officer. The offences, though, can still be made out even if the sender is a fictional person, and just so long as the sender has a belief that they were under 16. So being a fictional character, sending stuff to a fictional character is no defence. Neither, I should add, is the impossibility of any type of sexual activity going on between the sender and the recipient a defence. Now, there are some key distinctions between these 3 offences, however. The offence of transmitting indecent communications is basically made out where the communication's done in the circumstances I described, with the recipient and the sender fulfilling those qualifications, and the material that's sent is objectively indecent. It doesn't matter if the sender thinks it's indecent or not. If by the standards of normal people the material is indecent, that offence is made out. Procuring and grooming, however, both have very particular fault elements attached to them. And it's really in the subjective intention of the sender that these offences acquire their seriousness. And you would note there's a very substantial difference in maximum penalty between just sending indecent communications and then committing one of these other 2 offences that have these additional fault elements. Basically, procuring and grooming require that the communications with the under 16-year-old be made with an ulterior motive, and that ulterior motive, in the case of procuring, has to be procuring the recipient to engage in sexual activity with the sender. Now, for grooming, the intent has to be to make it easier to procure. So the way the legislation has established this is that basically procuring is the most serious. It would seem that grooming is set up as a a precursor to precursor to procuring, and then just simply sending indecent communications is viewed as substantially less serious. Now, the intended sexual activity that one is endeavouring to procure covers more than just face-to-face sexual contact. It includes any kind of communication that allows the sender to see or hear the recipient. So that means an attempt to procure a webcam sexual encounter, an attempt to procure a sexual encounter over the telephone will be sufficient to potentially qualify the person for an act of procuring. It doesn't, though, cover any sexual activity that might have gone on over a chat room, because that doesn't fulfil the category of either being able to see or hear the person, but endeavouring to procure someone for a webcam or a telephone sexual encounter will qualify. Now, the fault elements or the intention behind grooming and procuring have recently been the subject of examination in the Court of Appeal. Now, in the DPP versus FM, which was decided on the 29th of May of this year in the Court of Appeal, the Court of Appeal was called upon to examine precisely what the prosecution have to prove to establish an offence of grooming and procuring. Now, I'll give you a little bit of background about the case itself, because it does become important to understand what the issues were in the trial and why the matter ended up in the Court of Appeal as it did at an interlocutory level. Now, FM was a 52-year-old adult male. He was married. He had children. Over a period of months, on various occasions, he had used an alias to engage in chat room conduct with someone presenting themselves to be a person called Annie. Now, there was no dispute that Annie represented herself to be a 14-year-old schoolgirl and was in fact an adult female police officer. It's of some significance when viewing the issues at the trial that FM was also presenting himself in a false light. Rather than being a 52-year-old married male with children, he presented himself to be a 37-year-old masseuse. In some of the pictures he sent, it's fair to say he was depicting himself as generously proportioned, and certainly knew his way around the ab machine at the gym, according to the material he was sending, all of which differed substantially from how FM presented in real life. Now, there was no dispute that the chat room conversations that went on were objectively indecent in nature. He was charged with procuring, grooming and transmitting indecent communications. Now, FM was interviewed by the police, and after one interview where he denied everything, he went home, thought better of it, went back to the police station and said, yes, I am that person who was presenting himself as a 37-year-old masseuse, and he admitted being the person that sent the indecent material. However, FM disputed any intention whatsoever of having any kind of sexual activity with the recipient. Rather, he claimed that it was just a complete fantasy conversation engaged in for the purpose of sexual gratification. And I should say that included some portions of the contact where he raised the possibility of the two of them meeting up, and in very general terms he expressed how lovely it would be if they could meet at a generic location for some vigorous hand-holding, and in a very generic sense. Objectively read, some of the material he sent to the person he believed to be under 16 could be interpreted as him inviting that person to meet at a particular location for sexual purposes. However, he says, I never meant any of that. That was all just fantasy. That was all just things I was saying in the moment for the purpose of my sexual gratification at that time. Now, given that interview and given those instructions, he entered a plea of guilty to the charge of transmitting indecent communications. The Crown didn't accept that plea as clearing the indictment. The Crown put their 3 charges in the alternative and were intent upon running a trial to convict him of the more serious offence of either procuring or grooming. Now, prior to the trial commencing, the prosecution asked the trial judge to effectively give an indication about what directions he would give to the jury at the end of the trial. And what they invited the trial judge to do was effectively say that even if FM's version of events in his second interview, namely that this was all just fantasy and that he had no intention whatsoever to actually fulfil any of this or meet the person, if that was the case, the Crown said the jury should still be directed that that did not constitute a defence to either grooming or procuring. Now, what that would have meant is that FM had no defence. If the judge had have ruled against him at that point in time, he would have effectively had to plead guilty to one of the 2 more serious offences, and that would have been the end of the trial. The judge, however, ruled against the Crown and determined that fantasy was effectively a defence to the grooming and procuring charges. The Crown were unhappy with that and took the matter as an interlocutory point to the Court of Appeal. Now, in the Court of Appeal, more or less, the Court of Appeal ruled in favour of the defence and ruled in the same manner as the trial judge did, namely that fantasy is a defence to both grooming and procuring. Now, there are a number of interesting aspects of the ruling, though. One of the matters that got raised was whether, in proving these charges, the prosecution have to prove that at the time of this communication, the accused has a fixed intent to engage in sexual activity with the recipient of the email or recipient of the internet communications. And they said, no, that does not have to be established. It does not have to be a fixed intention. It can just be a possibility that's in existence. There was also substantial discussion about the nature of the intention and in particular what the legislation was trying to achieve by criminalising this type of conduct. Now, there's no doubt that the test for whether you're intending to procure or intending to groom is an entirely subjective one. There may well be material that objectively viewed may create a tendency in the recipient for that person to be more likely to engage in sexual activity or to be more likely to be, or to be recruited for sexual activity. However, that's not the test. The test is the intention of the sender. Now, in circumstances like this, where FM's saying, yes, I said all those things, yes, it may have had that effect on the recipient, but I didn't mean it. That's not what I wanted. I'm a 52-year-old married man. The last thing I want in the world is for the person on the other end of the email to see me or realise that I've been lying on the web chat room or realise that I don't look like a 37-year-old masseuse. Once that is the subjective intention, he's not guilty of the offence regardless of what the impact might objectively be seen to be upon the recipient, or indeed, if it was a real under 16-year-old, what the actual impact of that communication might have been. It's all subjective. The difference between those offences and the reason why one offence is more serious than the other is the ulterior motive behind the communications. Now, the other issue that arose in discussing this was how this matter might impact upon sentence. And interestingly, in FM, the Court of Appeal indicated that in these current circumstances, even if the accused ran the trial on the basis he wanted to run it, with fantasy being a defence, and then the jury still convicted him of procuring, the Court of Appeal indicated that in this particular case, sentence would likely be very similar to what he would have got for the indecent communication anyway, namely because in circumstances where even if the nature of his communication was intended to encourage or intended to make it more likely the person could be procured for sexual activity, in circumstances where he had absolutely no intention of having any sexual activity with this person, the moral culpability of that offending is, of course, lower. Now, clearly, that's going to be a significant matter to take into account in relation to sentences. Clearly, the offence is a lesser one where the person doesn't intend to fulfil it. And I think that's consistent with what you see when you read the second reading speech about this legislation. The second reading speech is peppered with words like, sexual predator and all this type of thing. It's clearly legislation that's aimed at preventing sexual abuse of children before it occurs. It's legislation that is aimed at online sexual predators who carry a desire to recruit under 16-year-olds for sexual activity. Now, and clearly from what the Court of Appeal said is that where that aspect isn't present in a case, that's going to be reflected in sentence. Now, can I add to this that the reason why this issue was such a live issue in FM was to some extent because of the nature of the evidence against him. The Commonwealth were prosecuting him based purely upon the material as it was presented in the chat room conversations. It wasn't the case where, for example, based on that chat room conversation, the police then set up a sting to say, well, let's go and meet at 5 o'clock at St Kilda McDonald's, and then when he turns up there, it's pretty clear what he was there to do. Without that additional piece of information from which the obvious inference can be drawn, namely, of course you were intending to procure this person for sexual activity because you've turned up at the exact time and place where you arranged it, it does become very difficult for the Crown to make out the charge. And as I say, in addition to that, absent that, in circumstances where somebody is claiming it just to be purely an act of personal sexual gratification based upon the nature of the conversation themselves, it also raises the question as to how much is in it for the Crown to try to pursue these additional, more serious charges that become more difficult to prove and carry, it would seem, very limited benefit, if you call a benefit being a longer prison sentence to be imposed. But I'll send around later on a link to FM, but one of the other significant features about FM is that once this issue got raised, it would seem there was no other case law about what the intention was, or what the parameters of the intention was in relation to either grooming or procuring, and that one might presume that's normally the case because these matters end as a plea of guilty. Very few of them seem to go for trial, and very few of them seem to have found their way to any kind of appellate court in any jurisdiction in Australia. But I notice it's 8:20 now, so I'll finish there and I'll hand over to Andrew.